The Supreme Court is reconvened.
Good morning. Welcome back to the Washington Supreme Court. Today
Recording
is
in
January
progress.
20th, 2022. We are now hearing our second and final case for today by video conference. It is In re the marriage of Watanabe and Watanabe. Opening is David Crouse for 15 minutes. Response by George Ahrend for 20, with 5 minutes reserved for rebuttal. Counsel, please proceed.
Thank you, Your Honor. Chief Justice Gonzalez, Justices, may it please the court. From the trial briefing to the briefing before the appellate court, and now to the briefing that has been done in anticipation of this hearing, this case has always been about the application of this court's ruling in estate of Borghi, as well as the ruling in marriage of Skarbek. And from the start, it can also be fairly said that there has been complete disagreement between counsel, presented very clearly from the trial court up until the time of this hearing. There is a disagreement over the breadth of estate of Borghi, the application of estate of Borghi, and whether or not, in fact, there's been an abolition of the gift presumption under marriage of Skarbek. And
can I ask an opening, overarching question? In dissolution matters, the judge has a great deal of discretion, and even if there's a presumption one way or the other, at the end of the case, the court could have done this very thing on equitable grounds, couldn't it?
In some respects, the court does have broad discretion in division of a marital estate. They can make a fair and equitable ruling, and that's rarely overturned on appeal. It's only overturned absent a manifest abuse of discretion. However, the trial court is also required to properly apply the law as it sits, which is also the application of gift presumption. And if the gift presumption doctrine as set forth in marriage of Skarbek was applied, then the court's ability to make the ruling that it did would have been limited. But in all candor, if the court had determined it to be entirely community property, in applying the standard, the court could have made a disparate division of the property before it. But what you would have had then is a 60-40 split of approximately $879,000 on the Ford property and $644,000 on the Clayton property. And those were never equitably divided in any fashion by the trial court because of, I would say, the disregard by the court, respectfully, of the gift presumption contained in Skarbek. So yes, there would have been great discretion, but yes, at the same time, there would have been additional assets before the court for division.
Can I jump in, Mr. Crouse, and just ask you a question about the competing presumptions? Because certainly in the area of community property, presumptions matter a lot, and they're everywhere. Do you think there's an inherent tension between a presumption of community property during the course of a marriage and the sort that Skarbek applied, and a presumption that the character of property, once separate, the right to separate property is just as sacred as the right to community property? So that presumption, is there an inherent tension in those presumptions that requires the court to draw some lines, or do you think there's a clear distinction?
Well, the first response that I would have to Your Honor's question is that this is a prime opportunity for this court to draw some lines as it did in estate of Borghi. So yes, most certainly this court is going to be asked to draw some lines, but at the same time, the gift presumption that exists under marriage of Skarbek is in exact accord with the presumptions established by this court in estate of Borghi. And to be specific about that, Your Honor, in estate of Borghi, this court, as this court noted, found that the rights of a party to their separate property is sacred. But in the long line of cases, which I will discuss, this court has also found that the rights to community property is equally sacred. And so the case of Scarbeck, I would say, walks hand in hand in exact accord with this court's ruling in state of Borghi, in that it recognizes separate property, which is property acquired prior to the marriage, as well as then affirming that what this court did in a state of Borghi, which is the inception of time rule. When was this property acquired? That was key to this court's holding in Borghi. And if it was acquired during the time of marriage, then both Scarbeck and a state of Borghi would absolutely recognize it as community property. So I don't see a tension in that. Your Honor, I rather see an accord between the cases. And while these legal issues are very important and the case law is very important, there are very important public policy matters before this court for this court's determination. And I do want to focus on public policy because that is very important to what this court does. In fact, this is most likely why this court has taken the case, our public policy considerations. And while this is certainly a case about real property, and I will discuss that, this is also a case about the value of partnerships. It's about the value of committed intimate relationship actions. And it's about the importance and value of marriage and marital acquisition. And our courts, particularly this court, has long recognized the concepts of joint enterprise and joint contributions. They're done in good faith with a fiduciary duty, all for the creation of a community estate for the benefit of both parties to these partnerships, whether they be a committed intimate relationship, because this is not just about a divorce proceeding. It's about probate matters like a state of Borghi. It's about committed intimate relationship proceedings. And at all points of time, this court has consistently upheld the importance of this partnership, the importance of creation of property, the importance of joint enterprise, good faith, fair dealing.
But counsel, isn't it necessary, aside from the policy issues, for the court to really undertake a characterization of the property in the first instance? So it's not just about these global values of community, but the import of characterizing what a property is in terms of its character before you even get into presumptions or evidentiary questions. Would you not agree with that?
I would absolutely agree with that, Your Honor, that the characterizations have been important as established by this court going back to 1922. If we go back to 1922 and Jacob versus Hoyt, this court is the first one that started the commingling presumption when we analyzed the mixing of separate assets with community assets, and then made the determination that there would be then a determination of community property. And that's part of the tracing analysis this court has done.
And why do we have to say more than what we said in Borghi? Why would we have to say more when it's really presumptions that can be overcome, they're evidentiary questions? What more really could we say or should we say?
Well, two things to that. I would be in full agreement with what this court has just proposed, that there is nothing that needs to be added to Borghi in the sense, and this has been very clear in our briefing, as I mentioned, going back to our trial court. Estate of Borghi talked about real property that was acquired before marriage. And in Estate of Borghi, even though this property somehow became inexplicably titled in both names after marriage, the presumption of separate property held. That's your time inception rule that I had discussed. And in this case, the court applied Estate of Borghi by analogy to a property, two properties to be exact, the Ford property, hundreds of acres in Ford, that was purchased long after marriage, and the Clayton property purchased approximately 15 years after marriage, which a state of Borgie would then say under inception of purchase rule that this was community property. But why this court needs to get involved is while we had settled law under Scarbeck consistently applied, at least in Division III Eastern Washington, the estate of Borgie case has been expanded, I would respectfully submit, beyond what this court intended, to say that this separate property presumption created under Borgie for property purchased prior to marriage, we are now going to transfer that into what is clearly community property, and we are going to now take some of that community property back because it traced to the separate property that existed prior to the marriage. That was never done in a state of Borgie. A state of Borgie never made that application. It was very clear that this applied to property that existed prior to marriage. And may I
Counsel, could I stop you there for a second? Because
Please.
I feel like I'm hearing you talk about presumption of community property, but that's not really what you're asking us to recognize here. It seems to me, and so this is a question, that you're asking us to recognize the application of the joint title gift presumption in this case.
You are correct.
It's not about community property presumptions, because here it looks to me like the trial court did assume, presume that because the properties in question were acquired during marriage, that they would be community property, but that if the spouse who's claiming it was separate property can establish separate property, well, then that overcomes the presumption of community property. And isn't that what happened here?
Well, this court is absolutely correct that your rendition of this is absolutely accurate, that the trial court did find that this was initially community property. And you are also correct in what I am clearly advocating to this court is for a continuation of the unambiguous ruling in Marriage of Scarbeck of gift presumption of community property. And what the principle of gift presumption, as this court has referenced, is that, and again, this applies only to jointly titled properties. It is a real property, but also it's a vehicle issue, a motorhome issue, a boat issue, anything that's jointly titled. What this says is that for property acquired after marriage, thus in exact accord with the state of Borgie, that when you jointly title these, you have been presumed to created a gift to the marital community. Now, to address some concerns that this court would have, that is a rebuttable presumption, and that's where things are a little different from what occurred before the trial court. Is the standard that this court has put in place is clear and convincing evidence that then there was not an intent to make a gift to the community. And that is easily remedied in a bright line rule where you would have some written documentation of an intent to keep it separate. And I can be very frank in saying that this occurs all the time. It is common, not just in a postnuptial, not just in a prenuptial, but in written documents where parties say, I am making a contribution of $250,000 towards the purchase of this home. And in the event of sale, death, divorce, I expect that this $250,000 will be returned to my estate. Happens all the time. It's common. And that's exactly what would occur if you set the bright line rule. Parties have a standard of which they can comply with and meet. And absent then a clear and convincing showing of intent to remain separate property, then there is going to be a gift presumption that applies. The entirety of then this property, in this case, the Ford and Clayton properties, are community property. Then as Chief Justice Gonzalez noted in the opening, then all of that property is before the court for a fair and equitable division, which is not what occurred here. There was nearly...
Could I stop you before you go on to that argument? And that is, I think you answered a question earlier about the So the butting of the heads between the separate property presumption or that property remains separate unless there's some showing that there was an intent not to have it be separate, and your joint title gift presumption. And I thought you said, no, there's no conflict there, but I failed to see how that could be true if what happened here is that it's acquired during marriage, so it's presumed community. Then the separate owner has to establish that it was separate, which is done. So then there's a presumption that it remains separate. So isn't that really in contradiction to another presumption that says that as soon as you jointly title it, the presumption of separate property drops off?
Yes, sure. And I see I'm out of time. May I answer your question?
You may.
Thank you, Your Honor. It is true that the gift presumption does take away the ability to trace separate property. There's no question about that. It does do that. But then we get back to a public policy analysis, Your Honor, of parties in a partnership, whether it be a committed intimate relationship, whether it be a marriage, they do intend to gift to the community. That is a common occurrence. And Your Honor, and I'll conclude on this, it is an equally common occurrence that in an event of a divorce, then the parties say, I didn't intend to make a gift. And there's not a better evidence of that than what had occurred in this case, where there was a quitclaim deed done on the Arlington property by Ms. Watanabe to create community property. It would meet the standard of this court's ruling in a state of Borgie, and yet she still came in and said, I didn't mean to make that gift. And that is what you will get in every dissolution, but it's not a divorce case. And this is my final point. I appreciate the time. It's not just a divorce case. This is a probate case. What occurs in the event of death where then the heirs come in and say, oh, this was a separate property, and the individual is not there to corroborate the intent to make a gift? Those are the issues this court is facing. Thank you.
Thank you, counsel. Response, please.
Thank you, and may it please the court, on behalf of Respondent Watanabe, now Solveig Pedersen, we'd ask the court to affirm the Court of Appeals. This is a marital dissolution property division case, and I think it's important at the outset to emphasize that of the judicial values that normally come into play in rendering a decision, finality is supposed to have preeminence in these kinds of cases. Finality regarding the property division so the parties can move on. And that's what this court said in Marriage of Landry in 103 Washington 2nd. And so before I dive into the merits of the argument capably made by Mr. Crouse, I need to point out that there's really 4 insurmountable obstacles that they haven't crossed and cannot cross in order to get the relief that they seek in this case. And that renders the discussion about Borgie a little bit academic, completely academic, actually. So obstacle number 1, there's no challenge to the findings of fact, no argument that any of the findings of fact by the Superior Court are unsupported by substantial evidence. That will become important as we talk about what the parties did, where the money came from, and so on. Number 2, the characterization of the Ford property, if it is error, and we submit it's not, has to be harmless error for the reason pointed out by Chief Justice Gonzalez. Of course, we all know that the trial court judge has discretion and the obligation, in fact, to make a fair and equitable distribution of the property, notwithstanding the characterization. And that's exactly what the trial court did in his findings. That's why the Court of Appeals below, something that isn't included in the petition for review, held on page 6 of the Westlaw slip opinion, that any error in the characterization of the Ford property is completely harmless. They have the burden to prove prejudicial error. They haven't done it, and they can't do it, because as this gets back to the first obstacle, the Superior Court found the parties did not have sufficient community income or cash flow to pay anything towards the Ford purchase. That's CP 168. And then on CP 169, the court concluded the entire proceeds for the purchase of the Ford property were from respondents' separate property. That's Solveig Watanabe, now Pedersen, respondents' separate property gifts and inheritances. That's at 169. And then, of course, I've cited the Court of Appeals decision. In the absence of prejudice, there's no grounds to reverse as to the Ford property because it is a fair and equitable distribution regardless of characterization. That brings us to the Clayton property, which is insurmountable obstacle number 3. Any arguments about the character of the Clayton property have not been preserved because they weren't clearly presented or argued in the Court of Appeals. That's what the Court of Appeals held on page 3 of the Westlaw opinion, footnote 4. And the facts are a lot more complicated. We recite the facts about there's 3 parcels that actually comprise the Clayton property, one of which was deemed characterized as community property based on the source of funds to acquire it, the other 2 of which were characterized as separate property. But we don't need to get into the weeds on the Clayton property because the issue hasn't been preserved. The Court of Appeals held that, and that was not challenged in the petition for review. The 4th insurmountable obstacle relates to the evidentiary argument. I didn't hear any, it's presented in the briefing, but it isn't raised in the oral presentation today, but that error is not preserved either. That's on page 7 of the Westlaw slip opinion, and the briefing goes into some detail about the nature of what objections were, or more importantly, were not made to the evidence that is challenged on the issue of intent to transmute separate property into community property just by including Ms. Pedersen's ex-spouse on the deed. And of course, we have, there was a focus of dispute at trial whether there was an agreement to transmute that property into community property. And the court specifically entered findings that Mr. Watanabe, the petitioner, was not credible and that he didn't believe that there was any agreement to transmute the property. This is another area, now that the evidence comes in without proper challenge on appeal, additional evidence to conclude that the error regarding the characterization is harmless, because whatever presumption may or may not have existed, there's no evidence that there was an intent, or alternatively, there was evidence to overcome any presumption that would apply as to the joint title gift presumption. So that any one of those reasons comprises a basis to affirm in whole or in part, depending on the reason. One deals with Ford, one deals with Clayton, and so on. But those are all huge impediments to granting any kind of affirmative relief to Mr. Watanabe in this review. But that brings us to more.
Can I ask you a question about one of those grounds? And it really is the evidentiary objection ground. And I'll just say to start this, Mr. Ahrend, that I'm concerned about the Parol evidence rule. If you have a writing pertaining to real property, and in this case, which isn't always the case, the quitclaim deed expresses the intent to create community property. So is your primary argument on the admission of testimony about the intent notwithstanding that statement, that just wasn't preserved, or is your argument that even if there had been a contemporaneous objection, that Parol evidence will always be admitted to contradict a statement on an instrument transferring real property?
So it's both, and some of it depends on hypothetical facts that we have to assume that may or may not be the case here. So, for example, Mr. Opposing counsel brought up the fact that this could occur in a probate case. Well, maybe you would run up against the dead man statute in applying in seeking to introduce oral testimony. But setting that aside, if we talk in the abstract, parole evidence, as the cases I think we've cited in our brief regarding a gift and intent to make a gift, is always admissible. So we've got, parole evidence issues with contract, with deeds and statute of frauds, and then with intent to make a gift. I don't have the cases at the forefront of my mind right now as I answer your question, but I know in our response brief, we cite the cases saying you can have oral testimony regarding intent to make a gift. I think that's a pretty well settled issue. And if you're inclined to decide it, maybe just flag the issue in this decision and we can bring it up in a case where it's properly vetted in the trial court and you've got, you know, competing briefing and arguments in a specific factual setting. But the larger reason, you know, judicial restraint, I think counsels against going any further than that, since it wasn't preserved. And since the holding of the Court of Appeals that it wasn't preserved further isn't preserved because it wasn't raised in the petition for review.
So can I ask, in terms of the cases that you cite, with the proposition, understanding the error preservation argument and the notion of not getting into more than needs to be addressed, the broad proposition that you advance seems to be that evidence of intent to transmute is on the table. So let me just ask you, what if this, instead of being a quitclaim deed, were a three-pronged community property agreement? Would we still allow evidence at the divorce trial that I didn't really understand what I was signing then? It was never my intent to convert my inheritance to community property. Would that be permitted in the face of an properly executed community property agreement?
So two things I would say about that. I don't think you could contradict. So obviously with like the example of a pre or postnuptial agreement, you've got certain hoops that have to be jumped through in order for those agreements to be enforceable, recognizing the nature of the relationship between the parties. But setting that aside, and if we're talking just in contract principles, I think you get to introduce evidence as to what the words mean, but you can't contradict what you said. That's kind of the Berg versus Huddisman rule, I think, that we apply in normal contract interpretation. And once we get over the additional hurdles that are required to enforce a pre or postnuptial agreement between parties having an equivalent relationship to husband and wife, once we get past that, I think we're in the realm of contract. And, you know, that's probably what we've got here. You know, so things like the reasons why we signed it. Well, we signed it because the bank wanted it. And that's one of the reasons why Borghi said the evidence of title isn't very important or worth much, because the financial trend, the reality of especially real estate transactions and financed transactions is that you have to have your title on there, or your name on title, whether or not you intend to make a gift. And so, you know, we still get evidence of the joint title as it was introduced in this case. Nobody objected to introduction of evidence. And so that's evidence of intent to make a gift, but it's not conclusive, certainly. And we're arguing that it doesn't give rise to a presumption either. And that underlies Borghi as well. Many of the questions this morning have highlighted the dueling presumptions that are at play between once property is separate, and here it was acquired by inheritance, so it's unquestionably separate, and that was found without any challenge or assignment of error by the trial court. So once property is separate, it is presumed to remain separate unless you got clear and convincing proof to the contrary. And but if you have a joint title gift presumption that runs up against that and says, well, no, you have to choose one, right? Because they both can't apply. And Borghi pointed that out, and Borghi did choose one. And the one it chose was to say, well, according to what the court described as well-established community property principles, title has minimal significance. It has significance, it has evidentiary value, but it doesn't give rise to a presumption. And so they chose the mode of preserving the presumption in favor of property retains its character, separate property retains its character as separate property, in lieu of the competing presumption. So this court, I think in Borghi, already made the choice between the dueling presumptions and kind of ends up resolving this case. And so then we get to, what is the argument? How is it, if Borghi has decided this, how is it that Mr. Watanabe even has an argument? And the way he does it is he says, well, Borghi involved separate property that was separate because it was acquired before marriage, whereas this case involves separate property that was separate because it was acquired by inheritance after marriage. And so there's this, the distinction, this isn't explicit, but underlying the distinction that he attempts to make between this case and Borghi is the argument that there's something magic about the date of marriage in the characterization of property. And there's some plausibility to that, because once you get married, it's presumed that all acquisitions are community property, unless, and this is what's missing, unless it's acquired from a separate property source like gift or inheritance, as it was in this case. And there's nothing in the Borghi rule or the Borghi rationale that would hinge the rule or the presumption, the rejection of the joint title gift presumption, the preservation of the presumption that property retains its character unless there's evidence that it's been transmuted. There's nothing in the rule or the rationale that would hinge on this date of marriage. The rule and the rationale hinge upon the property being separate. And the fact that it can be separate in different ways doesn't mean all of a sudden Borghi doesn't apply to any other kind of separate property that was acquired after marriage, as opposed to the kind of separate property that's acquired before marriage. And so in that way, we don't think that the distinction is material. We also think—
Can I jump in there and ask though,
Yes.
I mean, do you disagree though that the analysis in Borghi was focused on the time of acquisition rule in terms of at least a general, when do we have a separate property presumption? When do we have a community property presumption? Regardless of whether we have a titled instrument, just that time of acquisition rule.
so.
But you say the trial court here did follow, the Court of Appeals acknowledges.
Yeah. Was that important? Yes. Was it important in a way that matters here? No. The reason the court focused on the time of acquisition in Borghi was that was the reason why the property in question was separate, not because there's something that justifies different treatment of equally separate property acquired from a separate property source just because it happens to occur after marriage. So it was a point of focus, but that was part of characterizing it as separate property, not as part of the rejection of the joint title gift presumption.
So here you would agree, Mr. Ahrend, that we're dealing with community property presumption in the first step to the analysis that should apply in this case.
So this is separate property. We have unchallenged findings that the inheritance was separate property and the inheritance was used to acquire the subsequent property.
No, what I'm talking about is at the trial court level. I mean, I know where we are now, but at the trial court, the court started with the presumption of community property. Am I correct about that?
Oh, I think so. Yeah, and his rulings that
Okay.
the presumption everything acquired after marriage is community property unless it can be characterized otherwise, and that's what he did here.
Okay, and so that would be time of acquisition, right? Because it was acquired after marriage. So
Correct.
In that sense, the point of acquisition does play in this case, triggering the community property presumption, and then moving on to the spouse who's saying that the property is separate, having to establish the separate property or nature of those properties, and so it followed that course. Is that correct?
I think so, with one qualification. I don't think it was ever really disputed that the source of these funds was separate property because it was acquired by inheritance. Instead, we had this argument that there was an agreement to transmute it by the execution of the joint title. So I think there was probably some evidence about the source, but it was largely agreed and it was argued that it had been transmuted, not that it was originally community property because of the date of acquisition, if that makes sense.
I'm trying to sort of show the parallel or explore the parallel between Borghi and the time of acquisition discussion in that case. You only get the impact of Borghi is simply to say, what is the nature of the property? Is it community or is it separate? There was no assumption of community property because it was purchased outside of marriage. Here, there's a presumption that it is, and then we get to the next presumption, which is no, because she establishes it's separate property, therefore, we now are pretty much at the place we would be in Borgie. That is, we're dealing with separate property.
I think that's right. If I'm understanding you correctly, I think I thought that's correct.
Okay, because I'm trying to understand if there's some fundamental difference between what happened in Borgie, that is separate property before marriage, and separate property established after a presumption of community property, but then established to be separate property. I'm trying to understand why that would make a difference.
I can't think of a separate property as separate property. Once it's established as separate property, putting a name on joint title doesn't transmute it or doesn't give rise to a presumption that it has been transmuted into community property. I think those principles from Borgie apply with equal force here. And so then we get this Scarbeck case, this Court of Appeals case, on which the Mr. Watanabe relies for the distinction that he's trying to make between Borgie and this case. But the very proposition for which they're relying on Scarbeck cites marriage of herd, which this court specifically rejected as suggesting that it improperly or applied what this court described as the erroneous joint gift title presumption. And so any argument that Scarbeck has any sway here should be answered is answered already by the text of Borgie itself, which disapproved the very decision on which Scarbeck relied to state the proposition for which Mr. Watanabe relies on the decision. And so,
Aaron,
yes, ma'am.
I'm just wondering, what would you propose as the rule of law that should emerge from this case?
Just the same as Borgie, that there's no joint title gift presumption. So nothing, we need nothing further than that. We have all the findings unchallenged as they are that we need to establish that this is separate property and that we don't run up against any contrary assumption. That's sufficient grounds to justify the court's decision, even if we get past those original obstacles that I mentioned that require affirmance, regardless of how you end up resolving some of these other issues. Thank you.
You're talking no gift presumption in the joint titling period.
Correct.
I mean, I didn't hear any argument here or finding here that an additional statement, i.e. an expressed written intent to create community property, would just be subsumed. I think you're just talking about the title itself. Is that correct?
Correct. Correct. Title only. Thank you, Your Honors.
Thank you. Rebuttal, please.
Thank you, Your Honor. I want to change my closing argument to address the issues that have been just raised by counsel, because that highlights what this case is all about and what this court is being asked to do and asked to decide. Make no mistake, Your Honors, I respectfully submit that what you're being asked to do by Mr. Ahrend is to abolish gift presumption during marriage where properties are jointly titled. That was established in marriage of Scarbeck. It was also established in marriage of herd. I want to address those cases because that's critical, because this court has on multiple occasions, and appropriately so, asked about dueling or competing presumptions. And so I want to be very clear about this in my close. This court did not entirely overrule marriage of herd. It could have. It could have done so easily. It only partially, and this is meaningful, it partially overruled marriage of herd. What this court did is say that for separate properties that then later become jointly titled, the gift presumption will not apply. However, it left intentionally intact that portion of herd that said for properties that are acquired during marriage and jointly titled, the gift presumption does apply. This court did not do that, could have easily done so. Another point excellently raised by counsel is that in briefing is that marriage of Scarbeck pre-existed this court's ruling in a state of Borgie. And that's very significant because this court could have overruled, in accord with Heard, the holdings of Marriage of Scarbeck that says where you have property, and this is important, this is different than Borgie, that you have property acquired after marriage. And make no mistake, the Ford property was not acquired with separate property funds. It was bought with community earnest money. It was paid a mortgage payment for 18 months. It was a community estate where a property that had been jointly titled as to create community property was later sold and utilized to pay off a mortgage. But again, this is property acquired after marriage that this Heard and Scarbeck presumption applies to. And what this court is very clearly being asked to do is extend Borgie, overrule all gift presumption that occurs prior to marriage. Is that what this court wants to do? If so, why did it not occur in the state of Borgie as with regard to the community portion of Heard? Do we want to create a situation where a community is not encouraged to build an estate, make gifts, act in good faith with a fiduciary duty? And that's what's before this court. Thank you, Your Honors.
Counsel, you may briefly summarize the relief you request.
Thank you, Your Honor. What we are asking this court to do is to overrule the ruling of the Court of Appeals that inappropriately extends this court's ruling in Borgie. We're asking this court to set a bright line rule that gift presumption, as set forth in the portion of Heard not overruled, as established in Marriage of Borgie, applies to property acquired after marriage, that is a community, and that same bright line rule should indicate that that would be rebuttable by clear and convincing evidence of an intent to remain separate. Thank you, Your Honors.
Gratitude from the court to both counsel for your briefing and your oral arguments today. The case is submitted. We are adjourned.
Thank you, Your Honors.